topics of venue, how to pick a venue, how to maximize the injunctive relief you can get in the UPC, the bit on monetary damage and discovery, and any final nuggets of wisdom. So, without further ado, someone venue. If you're going to plan an enforcement campaign, most people file in Germany, and most of the people in Germany are in Munich. So why would you file somewhere else? What are the factors that would say, this is not a Munich case, this is not a Germany case, I'm going to go somewhere else in the UPC? Ari, thoughts on that?
Yeah, well, the world is your oyster, and I do think that there's a lot of choice. In a lot of these, for one thing, a lot of courts aren't busy at the moment. You've got the Danish local division, which is has its arms open and it's ready to receive cases. You've got the French divisions, and they're ready, willing, and able. And you've got Nordic Baltic. You might think that for particular sorts of technologies you want different divisions. You might think that you're going to get really fast sort of trial timings if you go to a non-busy court. And I have to say I don't fully understand. I know that statistically, Germany is about 50% of the cases at the moment, but I don't, and that's statistics, but I don't get the logic as to why people would automatically choose that, because you get roughly the same quality of judging and you get fast speeds from other courts. And I actually think that the decision isn't so much as to choosing between different courts. It's actually about strategy. And so you might want to, even a long arm type situation, you go to the domicile of the defendant, and that might be the Nordic Baltic division if you're going after a Nordic company. Mm-hmm. You could the interpretation of some of the likely defenses could be different, and if you're looking at an SEP case with a FRAND defense, then you'd probably if you're making the proactive move and you want your FRAND defense to be successful, then you might choose a non-German local division, because historically FRAND defenses in German local divisions have had very low success rates. So I think it's strategy driven, and I don't think it's preference for food, the climate, or whatever.
Right. Well, Marc, is it you're coming from Paris, obviously. Is it your view that basically, of course, you should choose Paris over? What would mitigate in favor of going to Paris as opposed to other places?
I would not say Paris is mandatory at all. I've got clients who have proceedings in different local division. Sometimes it can be good. I noticed that. For instance, of course, if you want some kind of order to present evidence, French judges are more used to it. They tend to be known as well for bringing a significant amount of damages, so not afraid of injunction. But I think mostly you should define your strategy by where the basics, which are where is the infringement, because you have basic rules which say that you should bring the case when there is where there is infringement. Do I want a long-arm jurisdiction? Sometimes you want to file it where the headquarters is. You also have, like it was said, the industry. Some legally qualified judges are trained scientifically. Some are chemists. Some have biotech background, so it can be really useful to have that as well. And I think that when you go, and I completely follow Ari reasoning, in that when you go to a really crowded local division, you have higher chances of success that your judge rapporteur, which has a significant impact on the procedure, because he's the one who is in charge of the procedure, will be the third judges, which is designated by the panel. Now, what we can see is you have a really strong competition between the different local divisions. So I would say, and it changed, my mind changed after some months. I would not say years because it's not that far, but it's true that I can see some uniformity between the local divisions. And also, I would tend to see, and what I see, for instance, in the life science these cases. Boehringer launched a PI in Portugal, in Lisbon, and I think it's notably due to the fact that even though the generic was said, I'm not going to launch there, it was even injuncted, and I'm not going to launch, but because the Portugal is the only one of the only European country when the sole detention of a marketing authorization can trigger a PI, while in other countries you don't have that. So that's why I would say sometimes you can look at the national regulation on actionage case law to understand the background of judges.
And Alexander, you're in Munich. That's the epicenter. That's where that's the hot place to bring cases. Are you bringing all your cases there, or do you go elsewhere?
No, I personally, I'm a little bit like Ari said. There is no need to go to Munich, and for the time being, I would feel also comfortable to file a case with the local division in Paris. What we recently did, of course, there was in addition the issue that the defendant had the seat in Paris, and so therefore we could also get Spain into this in our complaint, but it is not a situation where I see here with respect to technology, or maybe could be a reason, that you say that they had a kind of a case law in Portugal that for some reason they you have already an infringement very early, which is not the case in other jurisdictions. But where I see maybe still a kind of a difference is I would, for instance, not do a CC in a French in a German division, because that's something what they never liked to do. And how they are going to change now from one day to the other, that. And in France, it was a very known feature, so they know exactly how to do it. And I would then rather, or in Italy, for instance. So therefore, I would say that there are some elements where it plays out, but for the time being, you cannot simply qualify. And for us, it's a success that Munich is so successful, but it's not necessary to go there.
And Alexander, one more question for you is, fun fact, just about 3 weeks ago, for the first time, there was a suit brought in the Munich Regional Court where they asserted against BMW, they asserted American patents. U.S. patents were brought in Europe in the Munich court against BMW. So first question, is that legit? Like from a jurisdictional standpoint, can you do that?
Okay, so was a case brought in front of the district court Munich. It's a national case. Now they did it because there is this decision of the European Court of Justice, which gave possibilities to get into your case also patents of other countries. My first question was, does something like this work also with the UPC? I think there we could say no, because the UPC is somehow restricted to the European patent. And how would you get in US patent into your, let's say, into your claim? But we will see whether this works out. I'm not so optimistic that this is going to work out, because at the end of the day, there are also then some political power on which plays a role that I don't know whether the US would like that German courts start to decide on the infringement of US patents.
Right. It sounds strange to me, but who knows? We're all watching that one.
But coming back to the BSH, and there is now you can even say a standard, so that you can, if you go with the let's say with the seat of the defendant or his domicile, then you have the possibility to extend your let's say your UPC complaint to UK, to other countries which are not belonging to the system.
Ari, how do you like that now with the UPC, we can pull in, enforcement in the UK? How does it sit with you?
Well, Yeah, there's many perspectives on that. And one of them is that, okay, well, if that's a reality, then that's how we'll run all of our UK cases going forward. So we'll just, if you can't beat them in, then you join them.
Right.
And you sort of, you make it your policy to actually run UK cases remotely with a long arm component from the UPC. And that might become a reality for, some of the cases. But I think that the UK long arm was the one that they always discussed because it was particularly fun in the context of Brexit. I think to raise that example because it sort of it cancels out some of the effects of Brexit in some ways. But it's just it's a sub case of the long arm jurisdiction generally. And so I think the long arm jurisdiction seems to be with us to stay. And so I think the UK long arm as well will be with us to stay. But I do think that, when it comes to asserting US patents, that is a slightly problematic, that's going to be a more problematic scenario because you can imagine the reaction here when people find out that this is going on, and there might be, an anti-suit, for example, that's contemplated by a US court to prevent the interference in a validity challenge here. I mean, why would people tolerate a validity challenge that messes around with something that's going up valid completely? Court of competent jurisdiction here is addressing validity. Why should that be messed around with? So I can see real comity problems that arise from the unconstrained assertion of foreign patents.
Yeah, stay tuned. That case is Onesta versus BMW out of the Munich Regional Court. So stay tuned.
May
Yes,
I just say a word about it? Because ethically speaking, I find that completely crazy. In a way that UK said, I don't want to be part of this. I cannot be part and I don't want to be part in the EU anymore. And then they say, no, you're in. From a US point of view perspective, even though we have defense right, we don't have the word due process in our system. So you're going to have to explain to US citizens when they cannot use their car, or maybe why do you have recall? And they say, okay, but due process. You say, oh, that has been decided by a German court or a French court or any one of it. And I think more specifically, the strategic thinking, I'm not sure about it, because at the end of the day, there are only remedies, but each court remains as jurisdiction regarding the validity of the patent. So if you do that, for instance, in Germany covering the French territory, what I would do, I would say, okay, I'm going to go before the French judge. I'm going to obtain a super speedy proceedings. In 3 weeks, you're going to be in front of a judge, and you're going to have to explain why, so that even though the judge is here, he was waiting for your case. You ask to a German judge to interpret French law. So you're going to be in a very bad position, and I don't want to be before like to make a deposition in US proceedings defending why it was the clever things to do and it was completely normal that a French judge decided and interpreted US law.
But this is correct. This is, of course, in the line of the decision of the European Court of Justice. This means that the case must be decided on the law of the United States. So this means that they would have to provide expert opinions, which are then people explaining to the judge in Germany how this works in the United States, including the eBay whatsoever, what
Right.
is necessary to know it. And I see here, this is only one case. I see for them a particular risk because in Germany you can easily end up that the court is raising the litigation value to 30 million. And if you start very low on 1 million and they see something like this, that you have added a US patent, then I would fear in that situation that the court is putting up the litigation value to 30 million, which means then immediately that they have to add a lot of court fees. And this is considerable what you have to add in Germany. It will be then more than €500,000.
The other thing that's notable about it, or at least the UK long arm sort of version of the events, is that people think that that this thing came about and it was possible, particularly because of BSH as a result of recent developments, and it's one-sided. It sort of comes from Europe and affects the UK. That's not actually true, because when Brexit happened, the UK dropped out of the Brussels regulation, and the rules that prevented foreign patents from being enforced in UK patent infringement proceedings dropped away. And so the exclusive jurisdiction bar to asserting foreign patents disappeared, which means that the UK courts have had a BSH-like jurisdiction now for several years that just hasn't been exercised, but it could be exercised back towards the continent from the UK, so that if the pattern of litigating UK patents but from the UPC, for example, continues, then two can play at that game. And European patents could be litigated in the UK in relation to infringement that happens on the continent, and that's okay because the Brussels regulation no longer prevents it. The main rule stopping it. People haven't been talking about that a lot, but that is a possibility. It's not one that I think many people really want to engage in because it adds a lot of extra cost and complexity to the litigation. It's if you really want to sue someone, you might as well go in the court where they're at and sort of make it cheaper.
Well, I'll look for the headlines coming out of Paulo Gilbert on this. Thank you. Well, let's talk briefly about preliminary injunctions. We talked a lot about injunctions today, and it seems to me you win an injunction if you win the case. But preliminary injunctions, maybe yes, maybe no. What can you do to maximize your chances of winning that PI? Ari?
Well, I'm in the position of having fought off a PI and defended successfully against it, and so the reason why we won on that defense is because there was no urgency, or there's a requirement that you can't unreasonably delay. And so the lesson number one is obviously you have to do your prep work. So you have to have some good argument on validity, and you have to have a good argument on infringement, but then you also have to move fast. The urgency requirement is, I think, kind of under review in the UPC system at the moment. We've got two choices on urgency. One is the German model, which I call the sort of stopwatch model, which is when you find out about infringement, you start the stopwatch and it's ticking away and you've got 30 days. Which is a sort of more arbitrary requirement. So there's no reason why it has to be 30 days. Why can't it be 60 days? There's no real answer to that question. It's just a matter of policy that it happens to be about 30 days. Or you've got the Dutch model, which is that you have to apply for your PI before the harm that you're trying to guard against happens. And that's actually the meaning of the delay requirement. And we haven't had a proper ruling from the UPC on which one of those two is the correct model, or maybe the Court of Appeal has said something, but I would like some more clarity on which one of those two applies, because I think the stopwatch model lacks the logical basis.
Right.
Mark, you look like you're going to say something.
It's just that tomorrow you're going to get a decision on that. If that's okay, I think tomorrow you're going to get a decision on that on the PI case on pharmaceutical from the local Paris division, and I would completely agree with everything you said, and I will add that PI is specific in a way that they are going to look at the apparent validity of the patent. So if you're able to get some decision in other countries which are more, if you're the patentee, more favorable to the patentee, if you go to, I don't know, Poland tend to be really mature in terms of patent litigation now, but some Eastern country when the judges will tend to follow the EPO decision, then you're going to get a better case.
But you're not going to give us a preview
okay, the last thought, maybe it's a difficult question, because you have already a system which is very fast. In 1 year you get an injunction. So going the way through a preliminary injunction has a lot of risks, because maybe you're going to lose on elements which are then connected to the fact that it's even preliminary injunction proceeding is a front-loaded.
It's very front-loaded, yeah.
And it means that you can make so many mistakes as a lawyer that you rather say to a client, if it's not absolutely necessary, better try it with a lawsuit on the merits, where you have also in addition, the damage claims
Right.
and at the end of the day, the patent can be invalidated, and then I would rather recommend that the normal case gives you the chance to really look into the validity of the patent and to get a better, let's say,
Right.
more, better decision.
Right. And that might insulate you also on having to post bonds, for example, to cover the cost of an erroneous injunction. Is that right?
I think, yeah, right.
Right. So maybe the prudent case to go slow, because not slow isn't slow. Slow is 1 year, and that you may be able to develop a better record and be more methodical about it.
But there might be situations where you really need a prelim injunction. I don't know what is the situation in your case in Paris. What was the reason to use that, to take that track instead of not doing it in the simple way with a lawsuit on the merits?
It was a generic launch, so
Okay, so
the regulatory issue, and even there you get urgency. You have the real question on urgency, which was mentioned during the trial hearing, because they applied after the launch, while because of regulatory issues they could have applied earlier. So that's why it's going to answer your question regarding the Dutch or German view.
Yeah, the Dutch or German view. It's also interesting on, the Dutch v. the Germans. There's also the issue of balance of convenience or balancing of interests, and whether that matters for a PI in a sort of conventional common law sense, where you're trying to measure the harm to the patentee if the PI is not granted versus the harm to the defendant if the PI is granted, and trying to say whether the irreparable harm on one side or the other of that equation would outweigh the other. The Dutch view seems to be that you take a more common law approach to that versus the German view, which I think is more connected with the merits of the infringement and validity of the patent.
Let's talk about permanent injunctions. So it seems if you win your case, you're going to win at a permanent injunction. But at some point, I mean, there's one case I saw where it was a patent on an LED structure used in the pixels in phones, and that patent was found to be valid and infringed. And so the court enjoined the distribution of the entire mobile phones and ordered a clawback for phones in the distribution channel. So I read that as an American, I say, wow, you would never get the relief here. But does this create a problem that you've got patents on a small feature now shutting down the distribution of cell phones, and you apply that to cars, you apply that to servers, and at some point, if everyone's getting shut down and enjoined, do you have a problem? Is this going to be a hit to the economy with all these injunctions getting put in place? Ari, you want to try that?
Sure. So I think initially, sort of, the starting point is you do have a problem, because the injunction that you get out of the UPC is either the German style sort of recital of the whole claim, which may include the end user device, or it's just a Dutch style injunction which just says do not infringe anymore, which would then still include, if the patent claim includes it, the end user device. So the starting point is you do have a problem with that. I think the answer to it is to look at whether there's a workaround, because if there's a non-infringing workaround that could be used, like a different LED supplier, then of course you're not going to infringe. If there is no workaround that could be used to get around infringement, then you have potentially an essential patent or an SEP, but not one that's been declared, and you'd use a competition law argument to say that there's been an abuse of a dominant position, and therefore you should have a compulsory license to that particular patent on a competition law basis. You'd run that as a defense in your claim, and if you succeed on that, then there won't be an injunction.
Mark, thoughts on that?
I that's exactly what I thought. Again, Ari, I follow you completely. No, I think when you're in this kind of position, the only stick you're going to have to try to fight back would be competition law, but it's only limited to dominant position. So it means that you're going to have first to see whether the patentee has a dominant position on the relevant market, which is sometimes not the case. You can try to say that it created a dominant position, but yeah, I would consider that the competition law is could be something you could consider, notably given the fact that compared to the US, European Commission and national competition and market authorities are way more active. They are doing a lot of down raids, and they are not afraid of putting huge fines. But the threat of a fine or the threat of an action, because when you're the defendant, you are just making a complaint, you are just kind of launching a grenade. Right. And after that, that's the competition authority which runs the case. So it's going to bring a lot of the patentee would have to bring a lot of money to defend to that. So it could be a way to try to settle or to bring someone at the table at least.
Yeah. Alexander, are all these injunctions going to wreak havoc on the economy?
Yeah, of course. What you as lawyer can do is then in that situation, if there is a injunction out, it's somehow limited in terms of what kind of possibilities you have. And of course, what the first thing is that you try to, to hinder the other side to start in a way by if you make it dependent, for instance, from a security that such a injunction is then at the end implemented, and that's how we would normally address that situation.
Well, good. Well, we're running up against the end of the time. I want to ask each of the panelists for one nugget of wisdom that's not been aired already today about how to deal with the UPC, either on the offense or defense or just whatever observation we have. One nugget of wisdom. Ari, you want to start it off?
If you have a chance to be proactive, then be proactive, because otherwise you will fall into the trap of the claimant's choice of jurisdiction, particularly on PIs, and so preparing ahead of time, because you need to be very afraid of PIs.
Marc?
I would say that at the end of the day, you are doing patent law. So irrespective of the procedural issue, you're going to discuss validity of the patent with prior art, science, infringement. So pick a UPC representative who is at least able to do all this stuff. You are in a trial lawyer position, so tell a good story. Do you have an invention? Can you sum it up in one sentence? And was it in the patent application?
I think one thing Ari was already explaining it. It is for us a big difference from what we did in our previous professional life. This is the situation that you have really to prepare your case very well in order to start a case with the UPC, simply because it's so front-loaded. You need to have it prepared better than we did it in the past, simply because all what comes later after you filed is under risk that it will be considered to be belated.
And I will close from the U.S. perspective, as a U.S. lawyer just observing this, is we need to know this. We need to know what's going on. We don't need to be experts. We can call trusted counsel overseas, but we as American lawyers and American companies need to be watching this, because this is the big leverage these days in patent litigation and patent enforcement. And it is our jobs to know what's happening there and to know who to call. So with that, you know who to call. And thank you all.